Craig Eiland.
Thank you, Mr. Chairman. Here, Craig Eiland, individually and on behalf of Texas Trial Lawyers Association. So we need to change the.
So Craig, the record just reflects that you're here on behalf of yourself. Do you want us to add you're here on behalf of the Texas Trial Lawyers Association?
Yes.
And your position and their position on the bill
Is opposed.
Okay. Good.
All right. Thank you, Mr. Chairman. And just to let everyone know, we did meet with Chairman Harris and his chief to let them know that we were opposed, that we will continue to try to work with them if there is something that can be worked out. Because, you know, I hear that people talk about policy changes while the counties and hospital districts are here talking about recovering damages. I don't know if that's a distinction without a difference, but that's one of the things that I hear. So unilateral disarmament is basically what this legislation is. And when I began my 20-year career here in 1995, it was the beginning of tort reform. And one of the mantras in 1995 was, we need to bring Texas into the norm and not be an outlier with regard to tort law. And we have done that, has been done the last 20 years. If this bill passes, we will definitely be an outlier with regard to public nuisance law, which is in the restatement of torts, and it's in our pattern jury charge. And more importantly, if there was some type of national settlement that was based on a public nuisance, Texas would get zero, because as part of that litigation, there would be a motion to dismiss, and it would be granted because Texas would not have a cause of action that could be recovered in that situation. So with that being said, I do want to go through the bill and talk about some specific language, because nobody's done that yet. But as this bill as written, I don't know why anybody would support a state agency in New York impacting the rights of citizens and taxpayers of Fort Worth, or a city council in Rhode Island impacting Lubbock. Because if you look at the bill, it says a public nuisance claim is not cognizable in this state if an action was authorized by ordinance adopted by a state agency or a political subdivision. It doesn't say a Texas state agency, it doesn't say a Texas political subdivision, and it says the federal government, a federal agency, a state agency, or political subdivision. So any city ordinance from any other state could impact Texas taxpayers' rights. If you go to the next section, number 2, the public nuisance claim is not cognizable in this state if there is a statutory cause of action or an administrative enforcement that addresses the conduct. It doesn't say anything about damages. And so is that administrative penalty at the TCEQ, is it going to have the same damages available to the Harris County Hospital District or the Port of Houston that the TCEQ has? Usually that's like a $1,000 fine per day. And it goes to the state. It doesn't go to the local entity to offset damages.
Craig, where are you referencing right now in the bill?
Okay, it's under line 19, line 1, page 19, item number 2.
And you're on the committee sub. You have the committee sub in your hand?
Yes, sir.
Okay, all right. Keep going.
It says an action or condition that occurs or exists in a context where a statutory cause of action or administrative enforcement mechanism already exists to address conduct that is injurious to the public. Nothing about damages or where that goes. And then finally, the last one, which has been talked about, a product. So the public nuisance claim is not cognizable in this state if a product, regardless of whether it is defective, causes the injury. I'm not elected anymore, but I would not want to see me voting on a campaign television commercial to statutorily protect admittedly defective products that causes taxpayers damage in my community. I mean, that to me, does not look good. And that's what this says. You cannot have a public nuisance claim if it causes damages in your community. And lastly, Mr. Chairman, I know the light is blinking, but here's an example of where this would just doesn't make sense. I'm involved in litigation for PFAS, which y'all saw a bunch of commercial news about it yesterday, which is being added as a hazardous substance. In that litigation, Marathon Refining has sued 3M for damage caused by this legal product to Marathon's groundwater and soil at one of its refineries. And Valero has filed suit for that same damage, okay? Damage to the groundwater and the soil because they use this firefighting foam at their refineries. Now, if that same damage crosses the fence line of Marathon Petroleum's plant or Valero's plant and is now public damage to the water or the soil in the public right-of-way, that local community would not be able to recover under public nuisance claim. So you have the refinery that can sue the manufacturer and recover for private nuisance and private damage, but the city or the water authority would not be able to sue and recover for public nuisance for their damage. That, to me, is unilateral disarmament and is unnecessary.
Members, questions? Vice Chair Johnson.
Craig, you're always so eloquent in how you just lay it out. I'm struck by your example of the witness that was here on the previous panel, the district attorney who referenced well water rights. So when you're talking about your conduct example with the TECQ, I mean, her worst fears would be fulfilled based on this bill. Whereas there would be a $1,000 fine, to your point, but yet all the people in her county would have hazardous drinking water. Their county hospitals would have expenses in treating all of this medical care. There'd be other disruptions that the counties would have to pick up and pay for, but would be prohibited from recovering all of those funds expended with taxpayer dollars.
Because TCEQ had a $1,000 fine.
Right. Thank you.
Members, other questions? Okay. David Harper.